Okay, so this is the last video that I intend to shoot in this first series of videos in which I'm trying my best to replicate a divorce consult. I'm trying my best to replicate the consultations that I did and have done for people for decades and the advice and the things that I've talked to them about when they've come in for a divorce consult. And I'm trying to replicate what happens when people come in and they say, I want to know how it works, either because it's happening to them, something has been filed on them, or they're thinking about filing for divorce. So don't take anything I say as encouraging anybody to get divorced. I don't want anybody to get divorced. I do it because people go through it and they need somebody that knows what they're doing and that cares about what happens to them. None of this is intended to encourage anybody to get divorced. If there is one thing worse than filing for divorce, it's having a divorce filed against you. If there's one thing worse than being a petitioner in a divorce case, it's being the respondent in a divorce case, being on the defensive, pulling all of this together. We've talked about the procedural aspects of the case. We've talked about the property division. We've talked about child custody, spousal maintenance, child support, torts that can be filed, and some other miscellaneous things. If you have not watched those other videos, I would highly encourage you to go back and watch those, because until you watch those, what we talk about today may not make complete sense. So today I want to pull it all together. This is the part of the consult where we start talking about your options. The reason I can't give you what I actually give people in a real consult is because I don't know what your goals are. Without your goals, I can't elicit other facts from you to really go down different avenues that we would need to explore in a regular consult. In a normal consult, I would find out from you what your goals are. Where do you want to be in life? What do you want your life to look like, given the cards that you're dealing with at this point? I will talk to people about their options based on where they're sitting and what their goals are. So the easiest of those, the first of your options, is if you are thinking about filing for divorce. Nothing's been filed yet. Now, you may not know that because you may not have the ability to check, but hopefully an attorney will be able to check for you and find out whether something's been filed. If nothing has been filed and you are simply talking to an attorney because you are thinking of filing for divorce, then your first option is simple. Your first option is don't do anything. Your first option and the least aggressive option is to do nothing. I like to take the options from least aggressive to most aggressive. And your first option is to do nothing. Just don't file a case. Just keep living your life the way it's going. Now, I do have to stop here because we have not covered this in this video or others, but one of my philosophies and something I've lived by for 35 years of doing this is, if you know you're going to be in a fight, hit first. So if somebody comes to me and they know that they're going to be in a divorce, they know that their spouse is going to file if they don't, then I can tell them, hey, you have option number one. You have the option of doing nothing, but you're the one telling me that if you do nothing, you're about to have a case filed on you. In that case, I would tell you to go on to option number two. And the next least aggressive option is to file what I call a vanilla petition. I call it a vanilla petition because it's a petition to start the case without offending anybody. It doesn't have anything in it where it's making any demands. In fact, the most vanilla petition that I file are ones in which I simply say, hey, court, these are the people, they're married, they've got property, we expect they're going to come to an agreement, they have kids, we expect they're going to come to an agreement. We're asking the court to grant the divorce based on insupportability grounds, and then I have my signature block, and that's all there is to it. So what have I not put in there? I have not put in there anything about wanting a disproportionate share of the property, meaning I have not put anything in there that says my client wants more than half. My client wants more than half of the community estate. I haven't put anything in there about assigning all the debt to the other person. I haven't put anything in there about my client wanting to be named primary with respect to the children. My client wants child support. My client wants spousal maintenance once the case is over. I haven't asked that my client be awarded attorney's fees in the case. Now, here's the secret. My client may want all of that. And I may amend the petition later and put all of that in. But the idea with that vanilla petition at the beginning is I'm choosing the least aggressive option to get my foot in the door, to get the case started with me in the driver's seat, with me as the petitioner. So when you're moving up the aggressiveness scale, the next most aggressive option would be one in which you simply take that vanilla petition and you add in some of those things. You add in the things that you actually want. You say, hey, I want my attorney's fees out of this. You may not get them, but you put that in there. Now, I can tell you in advance, that is calculated to upset the other side. Anybody that gets handed a piece of paper that says that I'm going to go to court and ask a judge to order that you give me money, and especially if I'm saying I want the court to order that you give me money for me doing something and it costing money that you don't want to spend and that you don't want, that's the kind of thing that's going to upset somebody. So putting that in there, asking for attorney's fees, asking for to be granted on fault grounds, asking for more than half of the community estate, meaning a disproportionate share, asking for any of the community estate rather than just saying, hey, judge, we're going to agree. I'm now saying, hey, judge, I want you to decide this. Asking for spousal maintenance after the case is over with, that's something that is going to upset somebody. Asking that I be named primary of the children, asking that I get all the exclusive rights with respect to the children. Asking that maybe some of your rights be limited. Asking that you have to pay me child support. All of those are the kinds of things that when somebody sees those in writing, and especially if they see them in writing because some constable or sheriff or private process server has just knocked on their door, and when they come to the door in their pajamas or on their way to work, they get a piece of paper handed to them and told, hey, you've been sued. And they look at it and it says all these things are being demanded. Those are the kind of things that tend to upset people. Adding any of that in takes it up another rung on the aggressiveness scale. So we've got number one, don't do anything, which is not an option if you've been served. Number two, file a vanilla petition. Number three, file a little bit more aggressive petition. Next up on the aggressiveness scale is filing a petition and asking for temporary orders. You're going to have watched that first video for this to make sense. But temporary orders are what we call the case within the case. It's where you're saying to the judge, I'm going to put in the petition everything that I want you to do in the decree, everything I want the court to do in the decree. But I'm also going to ask that in the temporary phase, meaning at the very outset of the case, while the case is pending, you want a set of orders that say certain things. So what do you want? Well, the more aggressive you make your request in temporary orders, the more upset the other person is likely to be. So if you file a petition that is somewhat aggressive, because if you're asking for temporary orders, you're probably not going to file a vanilla petition. You're going to file a more aggressive petition. Then you're going to request temporary orders where you may say, hey, judge, while the case is pending, make the other person go live somewhere else. Give me exclusive use and possession of the home, meaning the other person is just like a stranger. You can slam the door in their face. You can lock them out. You can tell them they're not invited, they're not allowed to come over, asking that you be given the exclusive use and possession of the house, asking that you be given exclusive use and possession of maybe certain toys, whether it's a boat or an RV or a lake house, asking that you be given exclusive use and possession of the nicer vehicle, asking that the court order on a temporary basis that you be named the temporary primary of the children, that you be given temporary child support while the case is pending, with the idea being that you're wanting to get it in a permanent sense at the end of the case. You can also ask for temporary support, meaning unlike spousal maintenance that's at the end of the case, temporary support is something that can be ordered while the case is pending. If you're asking for that, I can tell you the other side, if they're not at least a little bit irritated about it, they probably don't understand what's going on, because you're saying, hey, court, tell them to give me some of their paycheck so that I can spend it while this case is pending, even if you're getting a paycheck also. And like we talked about in another video, there are very few rules for what the court can do on the issue of temporary support. Also asking in the temporary phase that the court order what's called interim attorney's fees. saying, hey, judge, make that person give me money to pay my attorney to fight against them. Again, that's the kind of thing that's calculated to irritate somebody. Moving on up the aggressiveness scale, we've had those other things we've talked about: do nothing, file a vanilla petition, file a more aggressive petition, file a more aggressive petition with a request for temporary orders. And then you get into the really aggressive things. Then you get into scorched earth, where you're talking about pleading additional claims against your spouse, tort claims against your spouse, whether it's assault, battery, defamation, intentional infliction of mental anguish, some sort of business tort, or whatever. You're going scorched earth and asking for a lot of things, asking for a tremendous recovery. That would be what I would say is the next on the aggressiveness scale, with an extreme request in the temporary phase. And then if you really want to go what I consider to be a scorched earth approach, that option is when you do all of that and you start your discovery immediately. That's the kind of thing that'll get somebody's attention. Now, if you are the one on the receiving end, take all of these things we've talked about in terms of options and consider them from the standpoint of, okay, well, I didn't strike first. I wasn't the one who got in the driver's seat first, but now what's my response going to be? Really, the only difference in looking at options is you don't have that first option. You don't have the option of doing nothing, because if you've been served, then if you don't do anything, you're going to lose by default. So you're going to have to do something, and then you just look at all of those options and decide which one of those options you want to do. If this was a real consult, I would have talked to you about what your goals are. After I talked through all of these options, I would then advise you on which of these options I think would be best suited to meet your goals. Which one of these would allow me to help you meet your goals, or at least meet them to the greatest degree possible in this divorce situation. That pretty much concludes the consultation. In the next video, I plan to talk about collaborative divorce. You may have heard about collaborative divorce, but there's a really good chance that you don't fully understand it. So join me in that next video and we'll cover collaborative divorce, because it's really a way to opt out of a lot of what we've talked about and opt into a separate system.